So what we're going to do is we're going to go on to our panel discussions. We're going to start with the insolvency one, which is basically, as the title suggests, us looking at insolvency and the tools being used to take on the different insolvency, including pre-packs and whether there are viable alternatives. We'll also talk about how creditors are losing confidence in the insolvency system and how this may be restored. So let me welcome our panellists to the stage. We've got Peter Best, Head of UK Asset Management at M&G Real Estate, Mike Jarvis, who's a partner at PwC, Adrian Cohen, who's a partner at Clifford Chance, and Professor Joshua Bamfield from the Centre for Retail Research, who I also happened to interview on the telly yesterday. I feel like I'm stalking you. But if you, one of you can come up to the stage, and if you give them a round of applause to welcome to the stage. Thank you. Now what we're going to do is each panellist will have a few minutes to give us their thoughts on insolvency, and then we'll kick off with some questions. Peter Best.
Thank you very much, Stephanie. Good afternoon, everybody. Probably not necessarily the most cheerful of pre-Christmas topics to start talking about insolvency, so I'll try and make it fun if I can, but it is a little bit of a dry subject. It might be a bit of a dry subject, but it's certainly been one of the hot topics, I think, of the industry in recent years. In fact, it started featuring so heavily on the BPF Commercial Committee agenda that we actually had to then create a separate committee called the Insolvency Committee. So we had to create a committee out of it because there were so many issues coming up. Now, I'm a surveyor by training, and I'm certainly not an expert in insolvency. Unlike some of you who I see in the audience, actually. I mean, some people out there know more about insolvency than I do. But so at least that means I'm not going to be standing here and blinding you with the technicalities of the process. That's not something I can do. But what I can do is give you some observations about how the insolvency process has been working in the retail real estate sector, and I suppose a little bit about where I think things stand today. Now, the Institute of Chartered Accountants were recently quoted as saying that Britain's economy is poised to grow at the fastest rate of any nation in the Western world as business confidence reaches a 10-year high. So we keep hearing all this about business confidence improving and the economy generally getting stronger. There are around 2,500 administrations in 2012, but quite a lot fewer so far this year. So 2013 is going to be a better year. So with the economy now bouncing back to health, will insolvency actually become less of an issue? Is it particularly relevant? Well, I fear it would be wishful thinking to think that it's no longer going to be relevant with the economy coming back. And I'm sorry to put a dampener on the fun of the occasion, but we can't afford to ignore the sheer scale of the debt that some of our companies still carry on their balance sheets. In his cheerful manner, our financial analyst at M&G Real Estate, he reminds us quite regularly, actually, that there are many what he calls zombie companies out there, meaning organisations that have got very high levels of debt, often actually significantly exceeding their assets. And these companies might themselves be owned by other companies that have very high levels of debt, and there might be precarious chains of ownership that are surviving really only because the debt can actually be serviced at the moment because of very low interest rates. And needless to say, these companies are incredibly vulnerable to rises in interest rates or indeed any other potential increase in their cost base. So with the onward march of internet sales, as Ben's talked about, and a surplus of retail space in the UK generally, it's pretty clear that the retail sector is not immune to the risks of this debt overhang. And some quite well-known names, well-known company names in the retail sector are still carrying uncomfortably large volumes of debt. So if insolvency itself has not gone away, what are the issues with it that I think are still causing concern to owners and investors in retail property? Well, I became involved in one of the early cases about company insolvencies, which was the CVA arrangement, and the case itself was Prudential versus PRG Powerhouse, which in my opinion rightly decided that the proposed company voluntary arrangement was unfairly prejudicial to landlords because it discriminated against landlords of the stores that Powerhouse wanted to close by writing off rents and particularly releasing parent company lease guarantees. Now, we thought that was very unfair, that there could be that kind of discrimination, and we and other landlords challenged that. And this compared with the treatment for other creditors who were actually offered full repayment of their debts. And of course, those other creditors were companies that Powerhouse needed in its new form to continue trading. And the more recent Miss 60 case reinforced that decision by setting aside a CVA which deprived the landlord of a parent company guarantee. And I think these cases fired a huge warning shot across the bowels of insolvency practitioners and the way they conducted their business. It encouraged them to think about carrying out their duties more openly and fairly amongst the different categories of creditors. We've also been seeing companies use the pre-pack sale route to rid themselves of unwanted lease commitments. And these are commitments that, of course, they freely entered into and freely negotiated with their landlords. And this is actually becoming a means of dumping all that debt that I talked about. And these walking dead or zombie companies have sort of taken this on as a route forward. And the creation of companies as Phoenix businesses, carrying on trading in near identical forms, has been a bit of a symptom of some, not all, pre-pack administrations. I think this has been particularly harsh, not on the landlords like M&G Real Estate and other big companies, but on the really small landlords, whose property income may be funding their pension and perhaps might be their only source of income. We've certainly seen small landlords disadvantaged in a number of administrations, and we saw that one example might be Travelodge, where some small landlords were quite severely lost out with the administrative arrangements there. Now, these small landlords actually carry little weight when the time comes to voting on supporting a CVA or a pre-pack sale. I think, though, on the other hand, where insolvency advisors have been prepared to engage in dialogue much earlier in the process, they've often found that many larger landlords, at least, have been flexible and have moved quite quickly to negotiate new lease terms. And these will have included lower rents and even lease surrenders to help businesses generally who are struggling with what will hopefully be just short-term trading difficulties. Even outside the insolvency process, we at M&G Real Estate took the initiative in 2009 to recognise the impact that the recession was having and would have on retailers' cash flows. And we offered all of our high street retailers the option of paying rents on a monthly basis rather than quarterly. And that's a policy that we've actually renewed every year since then. But landlords do have to be very, very careful in these circumstances, because competing businesses seeing their competitors gaining soft deals on lease terms or renegotiating their lease terms will argue that such an approach is itself unfair because it's propping up businesses that frankly are not competitive. For example, if I mention one, Stylo Barrett's and Barrett's, is the retailing model right? They've been into administration 3 times now, I think it is. Will their retailing model ever actually succeed? Landlords have been very supportive and helped them with their restructuring of the business, but the question is that model going to have long-term success? I think lack of transparency in the process is also a particular concern, especially when businesses are sold back to the owners of an insolvent company, free of all the debt and liabilities. And another example there would be Optical Express, as a very recent example, where DCM Optical Clinic was sold to its parent company, DCM Optical Holdings, on the day the administrators were appointed. And in the official creditors' report, the company had net assets with a book value of £12.2 million. Yet the company was sold for £130,000. So even allowing for factors which might lead to the asset value being overstated, I'll leave you to draw your own conclusion about the credibility of the process. It would certainly help if the report from the administrators in that case was produced a little more rapidly as well, as the lengthy delay simply increases suspicion and distrust in the process. I could also use the example of Comet Group as another example, and as we know, Vince Cable, Business Secretary, has ordered an investigation into the collapse of Comet, as the government is one of the unsecured creditors for tax and redundancy payments. Now, fortunately, at M&G Real Estate, we had the benefit of Norweb guarantees on our Comet stores, but we are still waiting the conclusions, or watch for the conclusions of that investigation with interest. So I think we need to see insolvency practitioners supporting legitimate company rescues, which have a reasonable prospect of succeeding, and not just devising a sort of strategic restructuring of businesses through deals with parties they're connected to. And I'm pleased to say that BPF is now working much more successfully with IP groups to share these concerns. In particular, the Joint Insolvency Committee. And one of this committee's tools is a set of statements of insolvency practice, or SIPs, and in particular SIP 16, which governs the conduct of IPs in pre-packaged sales. And the JIC has recently issued a revised version of SIP 16. It's still in draft stage, I think, but it requires additional information to be provided to creditors with regards to pre-packed sales. So whilst those changes are indeed welcome, and we're certainly pleased to see the guidance to IPs being strengthened, the BPF's view is that that doesn't go far enough to impose real penalties on those people who don't comply. A new IP complaints portal has been created on the Insolvency Services website. That's a good thing. It provides a mechanism for assessing the quality of work being undertaken by insolvency practitioners. And it also has a specific section for complaints about the misuse of pre-pack administrations. So it's a step in the right direction. The government has also commissioned a review on pre-packed sales, and this is being undertaken by Theresa Graham. The BPF has welcomed the opportunity to contribute to her review, especially around the issues I've been touching on concerning trust and connected parties, debt dumping and pre-event communication, amongst other things. One way the government might be able to consider bringing fairness to pre-pack administration is perhaps looking at whether an independent panel of experts could be established, which would examine some of these transactions and these deals and provide a level of scrutiny that you can only otherwise provide by adopting a full court process. But until action is taken, the BPF is actually advising landlords to protect themselves with stronger lease guarantees and also with rent deposits. So it's true, of course, that some of the zombie companies out there will probably recover with an improving economic situation. So in that sense, they're probably not accurately described as zombie companies. But there are probably a number that will clearly survive. For others, I think insolvency is going to inevitably be the conclusion and the outcome. And when interest rates rise, this, I think, will bring all those issues back to the fore of fairness, transparency, openness, and goodwill. All of those things will surface and rise back to the top of the agenda, particularly, I think, for this issue of small landlords and how small landlords are affected. So I have a feeling that the BPF is going to be occupied on this subject for some considerable time to come, so I think we'll continue to need that separate insolvency committee. I'm conscious of time, so I think I will wrap up there because we've had time for the panel as well.
Thank you very much, Peter. Let's get Mike Jarvis up now, partner at PwC.
We're changing role. Adrian's going to go first.
Oh, right, okay. Fine. Adrian first.
I'll finish my speech then.
Putting the chair in a place.
Mike will send his lawyer into the lion's den first to take some of the bullets. But Peter referred really to, I think, two cardinal principles in all of this. One is fairness, and the other is transparency. And I think that they really are critical to this whole subject matter. I mean, the point about a distressed situation is that there are going to be people that come out of it the worse off and not being very happy about it. And so therefore it's a question of how you ensure that people nevertheless understand what's happened, why it's happened, and that it's justifiable. Outside of the consensual restructuring, when you're looking at leases in the retail sector, there's really just two ways of doing this. The first is through pre-pack, as Peter mentioned, and the second is a company voluntary arrangement. Pre-pack is a particular class of business and asset sale, and as it says on the tin, really, it's all been pre-baked and it's executed upon the administrator being appointed. And the consequence of that is that those leases which are, if you want, economic or intrinsic to the business, are likely to be taken on by the purchaser of the business, and those which are over-rented or extrinsic to the business are going to be left behind. And obviously that does create strong emotions, because there are going to be those creditors who therefore recover in full and those that don't, and in fact may recover a derisory return. And so the question is, how do you bring transparency to this? How do you know that a pre-pack was the appropriate thing to do? And the classic justification for a pre-pack being that a sale in the course of an administration would do irreparable harm to the enterprise value of the business. And as Peter mentioned, there is SIP 16, which is a statement of insolvency practice issued by R3, the insolvency practitioners regulatory body. And that does impose a very high level of disclosure on the insolvency practitioner. So a pre-pack isn't something that any insolvency office holder would do lightly. And that statement of insolvency practice has been revised and reissued just a few weeks ago, and does impose very strong terms to ensure transparency. So that's the sort of principal protection for creditors, that they're not somehow being done over in a kind of sweet deal between connected parties. We can kind of come back to that in the discussion. The second is the company voluntary arrangement, and there'll be many of those in the retail sector to restructure leases. And Peter mentioned some of those, and one or two where we've had an involvement. And again, with a company voluntary arrangement, fairness is all important. I mean, there is a legal basis for challenging a company voluntary arrangement if it's unfairly prejudicial. Peter mentioned the Powerhouse case. There are two essential criteria for whether or not a CVA is going to be fair. One is the sort of vertical test, which is really, is a creditor being treated any worse than you would have done in a comparable situation if you don't do the CVA, so even an administration or a liquidation. And in those cases that Peter cited, being deprived the benefit of a parent guarantee, especially if it was a solvent parent, would actually leave the creditor, or the landlord in that case, in a worse position than they would be in a liquidation. So manifestly it wouldn't be fair. So that's one of the tests. And the other is what you might call the horizontal test, which is you compare how that creditor is treated to other creditors who are affected by the company voluntary arrangement. And where you have a CVA, the purpose of which is to enable some leases to go forward on their existing terms, other leases to have their rent reset at a discount, and other leases to be terminated. Obviously, creditors or landlords are being treated differently. So you can do that. The law does allow for a company voluntary arrangement to do that, but it has to be fair. And so you have to have a commercially justifiable, defensible purpose behind treating those leases differently, and to ensure that they are being compensated in some way adequately. Just a final point I wanted to make before I sit down is there is a third hot legal issue at the moment, which is to do, and Mike's had some involvement in this, is the treatment of rent in administration, and where it sits in the administration waterfall. There's been a series of cases over the last couple of years, Goldacre, Luminar, and more recently Game, which determined that if rent for advance rent, rental payment date falls during administration, then that payment obligation ranks as an administration expense if the administrator makes use of the property. On the face of it, you might think that's a good thing. It's elevated. You know, if an administrator uses the property for the benefit of the other creditors, they should pay for the privilege of doing so. However, by tying it to the rental payment date, it also means that the appointment administrators are structured around avoiding the rental payment date. And if they're appointed after the rental payment date, then they'll get a rent-free period. That is going to the Court of Appeal, which I think is going to be heard in February this year. So that's a very hot topic, and it shows actually how this whole subject is in a very unsettled area of law. There's continuous case law, and we don't really have a settled position on many of the kind of crucial principles which govern conduct in this context. So anyway, we'll be happy also to join in the discussion and expand on some of those points. Thank you.
Okay, thank you very much, Adrian. Let's have Mike Jarvis then.
Thanks. Thanks, Stephanie. Good afternoon, ladies and gentlemen. So I'm a partner at PwC. I'm a chartered accountant and an insolvency practitioner. I was one of the Lehman administrators on the 15th of September 2008, so I spent about 3 years down here, not far away in Bank Street, rather than Upper Bank Street, also administrator of Parmalat and Enron. And in the retail sector, as Adrian said, I'm the administrator of Game, which we sold to Op Capita last year. And we try and get involved in basically all of the cases. Some of them are audit clients of PwC. On JJB, I acted for Dick's Sporting Goods, who decided quite late in the life of JJB to put in 20 or 25 million pounds. So we acted for them on that, on recovering it rather than putting it in, I hasten to add. And things like HMV, we acted for the pension scheme. So we're seeing a lot of the retail failures and the sort of horror stories that you guys dread seeing on your desk in the morning in one way or another. I think a lot of this ground has been covered by Peter and Adrian, but in terms of process to save a business, you've got administration, straightforward administration. Going to administration, you have to have enough funding. You can't fund any administration, whether in retail or anything else, unless you've got funding. And in many cases, because of the changing nature, for example, of our banking system and the number of funds who come in and buy distressed debt, it's not a straightforward equation in terms of funding companies in administration. There is the pre-pack, which I'll sort of come back to. The joys of the pre-pack are that you have business continuity. You lose the sites, which are underperforming, but you keep a lot of people employed going forward. You keep the business, you keep the brand. And arguably, there are some really successful cases of pre-packs. HMV is trading very well. There was a report about Game potentially floating in Debtwire last week. So there are some pure and good examples of business rescues from pre-pack administrations. And also, this year there haven't actually been that many retail pre-packs. I was sort of scratching my head as to what they might be. And there have been a lot of really good pre-packs. I know this is a sort of retail conference, but in the people sector, so accounting firms, ironically, like Tenon went through a pre-pack, and that preserved a lot of jobs. Seymour Pierce, a stockbroker, went through a pre-pack, and very recently, Manchys, the law firm, went through a pre-pack. And that is they're really good examples of the use of that procedure to protect businesses and jobs. CVAs are the other area that Adrian mentioned. I'm not personally a big fan of CVAs. I think the problem with CVAs, and you as landlords will see this, is that because you leave ostensibly shareholders and management in control of the business, inevitably the cuts are not made deeply enough when they try and get rid of their legacy sites. And JJB is a great example of that, where it went through 2 or 3 CVAs, they all failed. JJB, at the height of its market cap, height of its trading, was a market cap of over £1 billion. And by the time it was sold to Mike Ashley, 20 stores went across for about £20 million, including stock. So massive value destruction through a series of CVAs, none of which went to the heart of the business, none of which were focused really upon the trading or the viability or the marketing or the brand positioning. They were all focused upon cutting out stores. And that's a real shame. I think that was an amazing destruction of value caused by CVAs. I've been asked to talk about sort of what's prickly about the sort of conduct of administrators and IPs. I mean, first of all, on pre-packs, Theresa Graham is running a kind of survey and a report on pre-packs at the moment. I met her about 2 months ago, and I said to her, the real problem are connected parties, Phoenix pre-packs, which Peter mentioned. And if you focus on, the Phoenix pre-packs, you will hoover up 99% of the complaints about pre-packs, because I think that's where the lack of transparency and that's where the noise particularly from landlord audiences, really comes out. Having said that, I think historically, insolvency practitioners could have had a lot more communication about pre-packs. They could have engaged with landlords a little bit earlier. I think that has got better over the last 12 or 24 months. But when pre-packs came to the fore, which is probably going back to, I don't know, 06, 07, 08, I remember I sold the Fishworks restaurant chain on a pre-pack, and that was at the height of the sort of debate about it. I think landlords and administrators do have more dialogue now than they used to, but I think historically IPs have been pretty poor at communicating. In terms of some of the areas that we have a lot of landlord clients at PwC. We meet with a lot of you about insolvency issues, and we try and sell you products like tenant covenant reviews. We think there's a lot more that landlords can do in terms of assessing the covenant and the creditworthiness of tenants. And the analogy I always use is a few years ago when pension deficits came onto the scene, we tried to, we made trustees and the pension regulator realised that pension deficits are a major creditor on the balance sheet of many different companies. And the pension creditor was not acting as a major creditor. They were kind of sitting back and letting things happen. And I think the same applies in some cases to landlords. There's a lot more you can do proactively around tenants and covenant reviews in relation to tenants, and behave like that major unsecured creditor that the pension deficit and the pension trustees found that they could do. And they got all these powers, of course. Finally, in terms of safeguards, again, in terms of pre-packs, no job is bigger than our brand name at PwC, and I'm sure most of the firms would say the same. So, yeah, we're never going to take a fee from a pre-pack without having done all the things that we should have done to make sure that that is the best value deal available in the circumstances. When a pre-pack is signed, it's a sale and purchase agreement. It's signed on the day the administrator is appointed. The administrator puts his licence on the line and his personal reputation on the line, because if there's anyone going to be sued for a pre-pack, it's going to be the administrator. So there are lots of safeguards, both the public safeguards, the legislation safeguards, and also the risk management procedures in the bigger firms in relation to pre-packs. And I think a lot of the noise around pre-packs has really come about because of perhaps a historical lack of communication by IPs, but also those connected deals where transparency certainly wasn't top of the agenda. So I'll let... we'll take questions later.
Yes, we will shortly be coming to questions. Just first of all, let's hear from Professor Joshua Bamfield.
Yes, Joshua Bamfield, as you hear, accredited person who's always chasing after you, Steph. Right. We're the Centre for, I'm the director of the Centre for Retail Research. Not true, actually. The last time I saw her was 2 years ago. We try to forecast what is happening in the retail sector more or less well. We don't necessarily take the same attitude as everyone else. But nonetheless, it's obviously the case that retailers have always been going into administration, liquidation, and they've always been getting into trouble. Outdated approaches, poor management, poor financial control, unwise acquisitions, bad locations, hopeless business model, all those sorts of things for generations have been hitting retailers. The difference now, though, of course, is that in the past, the traditional solution, particularly for medium and larger retailers, was somebody would take them over and acquire the custom base and the very prized locations that they operated out of. But that's not the name of the game. That's not the name of the game anymore. And in the last 5 years, probably 10 or 15 years worth of change has been forced on this industry by a combination of the growth of online spending and also the way in which consumer spending has gone into reverse over the period. And that has brought another problem up, which is probably the reason for the difficulties that landlords are having, which is that the current level of rent rates and the long leases involved, which historically retailers were very willing to pay. High rent was their friend. After all, high rents meant that inefficient retailers were forced out of business or had to vacate property so that I could take it over myself. And all that has changed again, and of course many retailers are caught in a very serious trap, and that's why administration and liquidation is the way out. Now, we publish information every month on a web page on our website, which is excitingly called Who's Gone Bust? And this is updated monthly. And as somebody who spent most of his life either in retailing or related to retailing, it's tragic, because often I know the people involved, and I can't give them a job either. And they do get in touch saying, oh, well, etc., etc. Presumably the same goes for you. Between 2008 and 2013, 252 major or medium-sized retailers went bust. This involved 22,300 stores, and the number of employees were 210,000. Last year, 2012, was the worst year since 2008. 4,000 stores were affected. This year, I gaily said after the first month or two, when store after store seemed to fall over, or retail after retail started to fall over, this was going to be even worse. In fact, I'm very pleased to eat my words and accept it hasn't been worse. Instead, we've had 50 companies go bust, 2,500 stores up the spout, and 25,000 employees, which, although it's bad, is certainly compared to, let's say, 2005, 6 and 7, would be pretty bad, is not as bad as either we were expecting or certainly less bad than last year. Now, I've also been asked to talk about what the future looks like, and obviously that's difficult. I think the best way to look at the future is to say rocky. On our website, you'll see we've got a future for retailers for the next couple of years based on what's happening in the economy, and it's quite glowing. So it's not any criticism of the Chancellor of the Exchequer that leads me to say that. Consumer spending is up, and obviously that will save many of the companies that would otherwise go bust, as we've already heard. But something like a quarter of the 44,000 retail businesses that put their information into Companies House are regarded as being financially vulnerable. Probably 10,000 of them, often very small, have a difficult future. In the last 4 years, almost 12,000 retailers have gone into liquidation, administration, pre-packs, and so on. Now, this does overstate the figure, but in other words, it is a difficult sector. It overstates it because retailers are always going out of business, and so one can't say, oh, well, 25% of all retailers are going to go bust, and expect out of every 100 retailers only 75 will survive. Company Watch looks at the financial data and has said, well, 46% of medium and large retailers are vulnerable. And on the basis of what's happened in the last 10 years, about a quarter of the people they classify as vulnerable go out of business. In the last few years, we reckon that just less than 3,000 insolvencies of retailers of all sizes have occurred every year, and we reckon this is going to grow by about 15% to 3,400. Of the medium and larger companies, 40 or 50 companies will continue to go bust, and that will involve about 2,800 stores a year. And of course, it's quite possible that as the world continues, some quite big retailers find that they're unable to cope because the stores that they retain are continuing to lose business, and their attempts to go online have been unsuccessful. And no doubt one or two of those biggies will fall over as well. Now, saying that we reckon that insolvencies, liquidations and so on will grow to 3,400, I think the risk is downside, that we're perhaps being too optimistic rather than being too pessimistic. I can be pessimistic, but unfortunately these days pessimism is the order of the day. We've seen better trading conditions, and that's good. We've seen also the government is starting to tackle some of the high street problems. But my response there would be it's probably too little and too late to make much difference to many of these companies that are in financial trouble. We're going to have rising interest rates, which are going to create problems for the zombies. Property prices are rising, so that secured creditors such as banks will say, oh, I'll be able to get my money back. Obviously many of these properties will move into the service sector rather than be retailers, but nonetheless that's a problem. Retailers who've been hanging on by their fingernails for 5 years, often, if you like, on the edge of bankruptcy or just over the edge. Better trading conditions may not help them anymore. A couple of months ago, we interviewed a sample of independent retailers who had quite large shops, 3,000 square foot plus, and we said, how long do you expect to remain in business? And they said, basically 40% reckon they'd be out of the business in 5 years. Now, okay, we didn't interview people before, let's say, 10 years ago to find out what the normal churn is, but nonetheless, a lot of people are saying, well, you know, I'll give another 5 years and then I'll pack it in. So in other words, for many sectors of the economy, of the retail industry, people are not saying, I've got a great business here, I want to run this for the whole of the rest of my life and hand it on to my children. They're saying, well, it'll see my time out, and then, you know, I'll go and live in Rickmansworth or somewhere like that. Online, we don't think online is going to take over the country, but even if, and now that online is about 12.7% of total all retail sales, even if growth falls from the current 14% a year cumulative to 10% a year, it is so large that by 2018 or 2020 it will have 20%, 25% of the market. And that means that obviously fewer stores are going to be required. There's less business in physical shops. Now you may say, oh, what about click and collect? And that's obviously a great solution, but it isn't a solution, of course. Click and collect also can mean actually lockers in petrol filling stations, lockers on the side of retail parks. It's not fundamentally about the way the high street works or large retailers work. So although click and collect is great, I don't see it as the answer to this conundrum of what do we do when, let's say, the units that were built as stores to sell goods to people now have only got 80 or 75% of the business that they had before. Now, we're not saying, and I'm not saying, that the future is the abomination of desolation, you know, where everything is dreadful. But problems will continue, and for the sector that you're interested in, I think the problems will get worse. I was also asked to look at, well, some of the costs of administration. For large companies, the answer is it all depends, doesn't it? But essentially, even the best-run business that's gone up the spout is going to have 30 people who are each paid £400 an hour to £150 an hour, crawling over the business for many months, and that's expensive. And if it's banks as secured creditors who are driving the move to end the business, they will obviously go for the most expensive or the more expensive administrators and IP specialists. And I'm not going to mention who they are, though I've got them written down here, so you can ask me after. As you know, the theory is what we're trying to do is repay creditors. But in the last 3 years, according to our figures, £61.1 million was spent on administrative fees and IP fees for medium and large retailers who went up the spout. Unsecured creditors, including property owners, were owed a total of £3.1 billion. And, of course, of that £3.1 billion, they got £33 million back. So, in other words, administration fees were twice as much as the actual amount repaid to the creditors, including landlords, but not exclusively the landlords. Now, of course, again, this is an exaggeration, because, of course, it all depends on the retention of title and, what other sort of terms and conditions of operating. But based purely on the figures that were in the reports, it's less than 1% of what's owed is returned for medium and large companies. So, in other words, we think the situation is going to worsen, but it's not going to be terrible over the next 3 years. But we think it's unlikely that it's going to improve. The other thing, of course, is that if you have a son and daughter who's wondering what job they need to have, then obviously to become an administration operator or an IP professional is obviously quite a good career for them nonetheless. Thank you.
Thank you very much. I'm going to take some questions in a moment, but I just want to kick off first of all on this idea of transparency, because Peter and Adrian, you both talked about wanting that. So, Mike, do you think the system could be more transparent?
Are you referencing pre-packs, Stephanie?
Yeah.
Yeah, so I think with pre-packs, as I said, when they started off, 06, 07, 08, they were quite a new thing. They're a very effective business rescue mechanism, and there wasn't enough discussion, communication, transparency between IPs and landlords and other creditors. I was at the time on the technical committee of R3 and drafted the SIP 16, which has been referred to, which kind of explains to creditors the marketing process that has gone on. I think that's improved the communication a lot. As Adrian said, SIP 16, now you're required, if you pre-pack a business as administrator, to inform the creditors within, I think, 14 days, rather than previously whenever the creditors' proposals came out, which could have been 10 weeks. So I think there has been more transparency. The problem with a business in trouble is that the more you tell people it's in trouble before it actually goes bust, the worse it gets coming up to the actual insolvency. So it's a fine balancing line. I think there's been a lot more engagement, though, with certainly the major landlords, and I take the point about the small landlords very much, and it's very, very hard, because for the small landlords each deal is absolutely 100% material, whereas the larger landlords can play more of a portfolio game. I think the communication between IPs and landlords there has gone up, has improved dramatically over the last 2 or 3 years.
Adrian, do you want to respond to that?
Yeah, it's quite interesting because to every action there's a reaction, and a lot of what we have in terms of the world of pre-packs is a reaction to, for those who can remember it, the recession in the 90s, when there were many more trading administrations, and the big criticism then was that all these trading administrations did produce huge fees for professionals, but actually were very value destructive, and pre-packs were used in rare situations where, usually people businesses, where if you didn't kind of go in and out quickly, your business would walk through the door because they'd just be hired by other people. And as time has gone on, as it's progressed, the use of pre-packs has expanded as a tool because the traditional sort of the paradigm of insolvency process was seen as so destructive that a pre-pack is seen as minimising damage to enterprise value, and that's kind of given a very high premium because of the focus on business rescue. But as I said, every action has a reaction. So now there's a reaction against pre-packs, because pre-packs in turn are open, or arguably open, have been in some instances to abuse, and around the transparency issue. And as Mike says, that reaction has manifested itself in the SIP 16 and its new incarnate. And I think hopefully one will slowly move to an equilibrium, which is sort of as optimal as you can get in a difficult situation.
Peter, did you want to?
I'd certainly support what Mike was saying about the improvement in the way that the dialogue is undertaken with insolvency practitioners now compared with how it was, say, 5 years ago. I think it has changed and dramatically improved. Unfortunately, it's not universal, but it is getting a lot better. In fact, I was looking back at some old notes and see that we had there was a definition of an insolvency practitioner a few years ago as someone who arrives after the battle and bayonets all the wounded. And I think probably now I would say that's not the case. That's an unfair comment.
I think the best battles are fought with good preparation, and that's what we do these days. There's a lot of preparation before a pre-pack.
Yeah,
but definitely the situation is better than it was because of the willingness of IPs to actually engage in dialogue earlier on. It's the connected parties issue, again picking up Mike's point, that I think is the real concern. Yeah. Okay.
Should we ask? Would anyone like to ask a question at this point to our panel? Yes, gentleman over there. We'll just get in a microphone to you, I think.
I just wanted to amplify what Mike was saying, really in relation to the whole process of pre-packs and retail. There are good reasons, and Adrian highlighted, and they were really about protecting intellectual property, know-how, situations where certain contracts would immediately determine in the event of an administration where you have to have a pre-pack. Retail isn't one of those situations. It's very, very rarely one of those situations, and it's very rare that you will see retail pre-packs. I think nearly all of the cases that we've mentioned and many, many others have traded because you don't lose your customers. It might be different if you were a business perhaps selling furniture where people come in and pay deposits and they're not going to pay deposits and wait for goods that may never be delivered. But by and large, the majority of retail insolvencies are sales that take place. I'm not saying there wasn't any pre-planning and discrete marketing, because insolvency is an expensive process. Having an administrator is expensive, so if you can cut down the time the administrator's in office, so much the better. But I would say 95% of retail insolvencies has an element of administrators trading with the view to getting best value. And the other point about CVAs, yes, they have failed, and I absolutely agree that in my experience, and I've been involved in one or two that have not necessarily got across the line or failed early on, because the directors, the incumbent directors, are very much glass half full rather than glass half empty. Good example was Oddbins, where actually we had a desire. There were 149 stores. The directors wanted to save 89 stores. In fact, the landlords, it was a sharing process, so all landlords, some stores were abandoned and closed down, but all landlords were being asked to share the pain to help really fund the CVA to work. It was HMRC who rejected it, and as a result, the company went into administration, and it wasn't pre-packed, it was sold later down the line. But the interesting thing, talking about objectivity, was that we ended up selling about 52 stores and not 89, because the objective purchaser isn't going to look at the marginal store and think, oh, it'll be all right, it'll come good. They will take a view and say, we want the ones that work. And the reason why that we've seen the increase in the emphasis on compromising landlord community in retail has been the paranoia, in my view, of retailers of, God forbid we should have to increase our profitability by raising prices in some way or other. We can't do that. We sell at certain price points. We have effectively done all we can, squeezed the lifeblood out of our suppliers. We can't compromise them any further. Landlords are our only solution. That's the view. But I have recently seen one or two or more inverted commas, advisors to retailers who are not necessarily, in fact, typically not insolvency practitioners, but of the retail agent community, who are seeking to exploit the negotiation of compromise of retail positions by suggesting that if you happen to have 150 stores, the fact that 20 of them are underperforming gives you some sort of right to compromise with your landlords, even if overall your portfolio is a net earner.
Yeah.
And using inverted commas the sort of restructuring and CVA label, which I do think is disingenuous.
Yeah,
but
well,
by and large, yeah, sorry.
Let's get Joshua to pick up on some of that idea that retailers are scared of increasing their profitability and instead going cap in hand to the landlords.
I certainly don't think they're interested. They're worried about increasing their profitability. They'd love to increase their profitability. It's the lack of profitability which is creating these problems. I think your analysis is absolutely correct, though, that people see landlords as people who can be exploited, cajoled, bullied, and browbeaten, so that the level of rent, which has fallen by 17% in retail properties since 2008, 2009, and that can be done. And certainly many retailers, irrespective of their agents, I think, have used the idea of restructuring their property portfolio and the possibility of some legal get-out as a type of business strategy, as opposed to, if you like, the last thing one could possibly think about. And certainly amongst quite a range of multiple traders, I think this is regarded as the norm. And it's the fact that although we willingly entered into these agreements, they'd no longer suit us. Therefore, we want to walk away from them unless you reduce the price in order to give us a profit. And I think that's the remorseless logic behind the way in which the market is going these days.
Did you want to pick up on that, Mike? You look like you're about to.
I caught your eye, didn't I? I think in insolvency, people lose money, I was asked to do some research about corporate finance guys the other day, and said pick up some ladies' clothing retailers and what sort of multiples they've had or they've achieved in a distressed environment. And when you look at Aquascutum, Jaeger, Peacocks, all that sort of stuff, none of these businesses were actually making any money at the time they went bust. So it's a fact of life that in an insolvency people are going to lose money, and the landlord community, has been one of those. Every distressed retailer I see has got too many stores. There's too much legacy, and that's why we have insolvencies.
And Adrian, coming back to this issue about rent, which you talked about, because often when I'm talking to retailers and out and about, the rent day is a massive issue for them. But as you say, there's an element of what happens when you go into administration and that's due. I mean, how do you think that's going to end up, that situation?
Well, yeah, it's a sort of it's a byproduct, it's a sort of unintended consequence, I think, of some legislation that was introduced in 2003, which introduced this concept of administration expenses akin to liquidation. And prior to that, what would happen is the administrator would negotiate with the administrator would negotiate with the landlord rent that was affordable by the company in administration, whilst the administrator makes use of the property. If the administrator took a very extreme position or hard position and wouldn't pay anything, then he risked the lease being forfeited, because the landlord would complain to the court and get a lifting of the moratorium, and so there's a sort of balance. The court would do basically, if it ended up in court, they'd do a balancing exercise to work out the relative merits of the landlord's interest and the interest of the wider creditors in continuing to use the premises. That was changed with the introduction of these rules, and it's created a very, Lee, I remember you wrote on this, just spoke before, wrote on this subject. It's created a sort of bit of an arbitrary environment. So if a rental payment date falls due during the administration, so say for advance rent, then it's payable, the whole of that quarter is payable, even if, say, the administrator is only in there for a week, and even if the administrator only uses part of the property, which is, not in the interest of creditors, and in a way gives a windfall to the landlord, you could say, in relative to the other creditors. Obviously not a windfall because it's only that quarter. On the other, so on the one hand, it creates that distortion. On the other hand, it encourages people to make appointments immediately after the rental payment date, and then the administration gets a 3 quarters rent effective, a free quarter of not having to pay any rent, which again is it's a distortion in the way that landlords are treated. But that's a sort of byproduct of these cases, and it's difficult to know how. Mike might be closer to it because it's his cases before the Court of Appeal, but difficult to know. But it would be nice if we could somehow move away from this sort of very rigid application of administration rules. This environment's caused all kinds of problems in insolvency, because we also had a similar problem again in other Mike's cases of Lehman's and Nortel in relation to pension. Pensions were mentioned before. Until it went to the Supreme Court, pension liabilities were ranked as an administration expense, which created a huge distortion. So we're being faced with some very unhelpful law at the moment, which is making it very difficult for practitioners, making it very arbitrary as to sort of who benefits. So, but hopefully, hopefully the Court of Appeal will find a way to reach a commonsensical solution to it.
So the Court of Appeal and some of the landlords are involved as well, inevitably, is in February, I think, February the 12th, so that's the hearing, and obviously that could go to the Supreme Court. I really shouldn't comment on it, I'm afraid, but I think Adrian's view is that common sense should prevail, and we would support that.
Okay, would anyone like to ask another question? I think someone popped their hand up there. Yes, the gentleman there.
It seems to me that the biggest issue is that unsecured creditors simply don't trust the system and the processes. They see that processes, or they believe that processes are there for the benefit primarily of secured creditors, and that those that are involved in the process are primarily advising the secured creditors. It could be argued that much of this comes around as a result of changing the process from in court to out of court with the Enterprise Act, and perhaps things would be much better, and there would be more trust in the system if we went back to a system where you don't get an administration order other than in court.
Yeah, it's a good point. The creditor confidence. Who wants to pick up on that?
Just briefly. Again, yes. As the speaker just said, this comes out from the changes in 2002, which the purposes were to reduce the cost and access also to the court, access to insolvency proceedings. So it's thought there at that time there had been insufficient uses of administration and overly use, you could say, of liquidation and receivership. So the idea was to try and encourage use of administration as a collective procedure. And one of the innovations was that either the directors or a bank with what's called a qualifying floating charge could appoint an administrator out of court. So, like all these things, it's sort of balancing conflicting imperatives. So it has had the effect of there being a vast increase in the number of administrations, which is a collective insolvency procedure using an insolvency office holder over, say, private bank solutions using a receiver or liquidations. So, you know, it's a question of whether or not that's gone too far. But I think the answer is not, I don't think personally, to move away from privately appointed administrators, but as is happening, to sort of increase the level of scrutiny and transparency in order to recreate or engender that confidence.
Yeah.
Can I ask where that level of scrutiny is going to come from? Because at the moment it's completely absent.
So the level of
Scrutiny. Where do you think that level of scrutiny will come from? Because the gentleman thinks it's absent.
The detail, for example, that's now required to be provided in a 616 statement is considerable. An insolvency practitioner now has to provide a very detailed narrative to justify why they were prepared to execute a pre-pack. So, and as Mike says, you don't put your name easily to a pre-pack. So, you know, given the combination of a highly regulated environment and the need for greater transparency, that should have some effect in increasing that level of confidence.
I suggest that's simply not working. It might be at the top end, at the very, very top end, as Mike suggests, but generally speaking, it certainly isn't.
Is there anyone else who wants to chip in on this?
Just on the numbers and trust and creditors, and I wrote to the Grimsey report authors because the numbers are incorrect. They hadn't asked me about any of my cases, and the amount of money that we return to creditors through reservation of title, for example, in retail situations is enormous, as creditors have the right to recover their goods or be paid for them. So on a transaction like Game, the return to creditors, video games, all that sort of stuff, exceeded the total that was quoted in the report, and I asked the report authors to change it, but they ignored my email. And I think there are landlords, obviously, in certain cases in insolvencies have security going forward because the business is sold. Suppliers have reservation of title. Employees who are contingent creditors also continue in employment. So I think a lot of the noise about the loss to creditors from insolvency is simply incorrect and doesn't have full data. And I know for a fact that hasn't been addressed by the Grimsey report. I'm not knocking it entirely, but I did make a point about the returns to creditors.
Is there anyone on the panel who disagrees with that? No.
No, I think the scrutiny point, I would agree with. I sort of touched on it anyway as I was talking about. It's one of the things to look at. I mean, we talked about things like, do you have an independent expert panel? Do you have... otherwise, you've got to go back to the court proceedings, I presume. I mean, I'm not an technical expert in insolvency, but that seems to me a bit of a gap.
Gentleman there's waving his arms around.
So on the point of scrutiny, I was, until April, president of R3, which is the trade body for the insolvency practitioners, and there has been, at one stage, there was a suggestion by the insolvency services that all pre-packs required a 3-day notice period, which they didn't really explain what happens during those 3 days or indeed after, and you have to give notice to creditors, and that was found to be unworkable. But there has been and is continuing dialogue in how one scrutinises pre-packs, and in particular connected party pre-packs. And pre-packs that are not literally the day that the administrator is appointed, but you'd have to capture a reasonable time period, because if it was just one day, you'd simply, if you were dodgy, you'd do it the day after and say, well, that's not really a pre-pack, but actually it is. What we have recommended is, and I think it's fair to say that the majority of what one might consider to be unsatisfactory pre-packs to connected parties tend to be with smaller businesses, and typically because of reputational risk, perhaps smaller firms of practitioners. And we have been in dialogue with the insolvency services and other regulators, and the suggestion that is being still mooted is that there be where there is a connected party pre-pack, there is a minimum sum that has to be set aside by the administrator to scrutinise the transaction by a subsequently appointed liquidator if the creditors so wish. So in other words, if you sold a business for, let's say that minimum sum was £15,000, so there's £15,000 left for an independent liquidator to look at the pre-packed transaction. So he is there policing, not the directors, because I think it was alluded to earlier, it's the practitioner who is the insurance policy for the directors. If he's selling it back to the directors or to the shareholders, it's his neck that's on the line. So the scrutiny would be by an independent practitioner of the conduct of that other practitioner. And that should focus, if nothing else, focus the mind of any practitioner who's thinking of doing a sort of light touch pre-pack to a connected party, the real risk that his conduct will be investigated properly by an independent liquidator if the creditors so wish.
A lot of nodding on the panel there. Would anybody else like to ask a question before we end this session?
There's been a lot of talk in the last 10 minutes about pre-packs and insolvency practitioners. I'd like to focus a little bit on the position of landlords, because I think the law generally over the last 15 years has given landlords a bad deal in relation to insolvency. I think everyone recognised that perhaps they had too much power 20 years ago, those of us who work in the insolvency industry, but their power has been really badly eroded in terms of ability to strain, to forfeit, etc., and that has very much created a fundamental change in the balance in terms of what is going on here. You look at other creditors who still have rights to terminate their contract, for example, on insolvency. And I think, Mike, you alluded earlier to the fact that obviously that is one of the fundamental reasons why pre-packs happen, because the value is eroded. Does the panel think that there are other things that could be done which could change the balance, which means that pre-packs are not as much of a necessity as perhaps they are considered to be at the moment?
Peter, do you want to start us off?
I think you make a good point about the general change of the law anyways, making something slightly more difficult for landlords to do to protect their position. But overall, I tend to try to look at this fairly objectively and not too much with my landlord's hat on. We've got to accept that some businesses are going to fail. So it is going to happen, and when that happens, there's got to be a process for then dealing with it. And I think we probably have to accept that your landlords are going to lose out as one of the creditors when that happens. You do have to be very careful about selecting your tenant in the first place. And there's much more scrutiny about how we assess tenants going in now than was the case even a few years ago. But we know that a certain proportion of them will fail. And there's not much we can, with any process, I think, that's quite difficult to get round. I still think the way forward is to work more closely, picking up on Mike's point again, with the insolvency practitioners to continue to refine and improve the existing processes and filling in the gaps that are there at the moment, for example, with the scrutiny issue. And I think it's an interesting suggestion that was made earlier. So I'm not sure that there is a lot for landlords to campaign on here to change the process or the law or the system. It's about working with the existing processes and systems and improving them, I think.
Joshua?
Well, what we've heard is really that as a result of the expression, people have become cleverer. Retailers have become cleverer, if you like, in administration, liquidation as CVAs as a form of business strategy, and in addition, the use of retention of title and changed contract conditions can help. The people who are suppliers or have some sort of contractual relationship with the retailer, so that they're no worse off than they would otherwise have been, and ensuring that property landlords are in a similar position, just seems absolutely straightforward. Obviously, it's a real problem for retailers if that happened, because, of course, they are people who trade from individual outlets, and if landlords, if you like, don't go along with the continuing to let the business trade, then obviously that's probably the end of the business. But in terms of the need for equity, which has been stressed, I think, by all the speakers here, obviously it's important that the property owners aren't disadvantaged in the way they are at the moment.
Is there anyone who wants to give a final thought on that, Adrian?
Yeah, I mean, Joshua talked about suppliers and retention of title, sort of reviewing their contracts, and I think Peter, you picked up on that as well, opening remarks. There's possibilities for bettering the position of a landlord through review of the lease. It's been suggested to me that leases could be made to be more akin to loan agreements. So you could, for example, have financial covenants, information covenants, sort of triggers which give the landlord a seat at the table, as it were, at an earlier stage. You can look at likewise a sort of enhanced security, I think Peter mentioned as well, to strengthen your position. You can look at use of master or portfolio leases to try and restrict the ability to have leases cherry-picked. So there are various things that can be done, but it also, of course, and so far as rent being payable as an administration expense, for example, you could have a provision which flips the rental payment from being quarterly to being monthly in circumstances where the company becomes distressed. But then it's a question of your relative bargaining position and whether or not you're going to be able to attract the tenants you want if you're kind of going to try and impose those kind of terms, and also where that fits with the retailer's banking finance as well, as to you're then looking at the relative position between different suppliers of credit to the retailer. But these are all sort of points which are sort of work in progress, really.
Okay, I think we'll probably end it there. Please, can you thank our panel, Professor Joshua Bamfield, Peter Best, Adrian Cohen and Mike Jarvis.